Come to order.
All right, the record reflect we are back in session. Parties and counsel are present. All members of our jury and our alternates are present. So we had some discussions with juror in seat number 5. We thought we had something worked out where he could continue to deliberate at least in the afternoons, and that ended up not working out. So I want to thank you for all of your time and effort and dedication, your patience in being here all the way through with us. I wish there was a way to accommodate everything, but obviously that's not going to work out. So we're going to go ahead and excuse you at this time. And that means we're going to call one of our alternates to take juror number 5's seat. Now we have our trustee Leo back.
That would be juror number 376, which is alternate number 5, Robinson.
Okay, so a couple of things before we actually send you out to begin your deliberations. First, counsel willing to stipulate the jurors may be excused to various recesses, including noon and evening recesses, without further admonitions.
Stipulate, yes.
So that's probably the most important stipulation, because that means now, within reason, you're on your own schedule. You decide when you come in to start your deliberations, you decide when to take your breaks, you decide when to come back. So if someone, I know Monday a couple people said there were a problem or something, you don't have to clear it with me anymore. It's just, here's our schedule, if someone can't be here, we'll come in at this time. That's fine. Within reason. We expect you to keep reasonably close to the time frames we've been keeping. If you suddenly start saying, yeah, we're going to start coming in at 11, we're going to start going home at 2:30, yeah, we might not go for that, but generally, you're on your own schedule. So you don't have to worry about if someone has a doctor's appointment or something that you need to accommodate. Just go ahead and do it. Counsel willing to stipulate if there is a request for readback of any testimony. The court, of course, will advise counsel of the request. Once it is determined what is to be read back, the court reporter can then go into the jury room for the readback in the absence of counsel, parties, and the court for the readback, with the understanding that there would not be any other deliberations or questions during the readback.
Stipulate.
And Mr. Merritt, that's agreeable with you?
Yes.
All right. And then counsel also willing to stipulate if there are any questions from the jurors. Again, of course, the court will advise counsel of the question. Once it's determined what the appropriate answer is, if it is a relatively short and concise answer, that the court can then go into the jury room, again in the absence of counsel and parties, but of course with the court reporter, to give the short agreed upon answer. But if there's a question that's likely going to involve an ongoing discussion or another issue that counsel would prefer to have in open court with all parties and counsel present, they can request that, and we would do that.
Stipulate.
And that's agreeable with you as well,
Yes.
Mr. Merritt?
Yes.
Okay. I think those are the issues. So we'll go ahead and send our 12 jurors back into the jury room to begin your deliberations. Bring your notebooks with you. As I said, it's going to take the clerk a little while to gather up the final packet of jury instructions and all of the exhibits that have been admitted into evidence. We'll get all of that back to you maybe this morning, probably this afternoon. Okay? Okay. Clerk, let's go to Bailiff. Thank you.
Please raise your right hand. Do you solemnly swear that you will keep this jury together in some quiet and convenient place, and not permit any person to speak to them or communicate with them, nor do so yourself unless by order of the court, or to ask them whether or not they have agreed upon a verdict, and to return them into the court when they have agreed, or when ordered by the court, so help you God?
I do.
Okay, our 12 regular jurors follow Bailiff into a jury room.
Make sure you bring all your stuff.
Our alternates, you're on call. If there's anything I can do to help with your situation, let me know, and I'll try to assist if I can.
Thank you.
I should have let, it was occurred to me, I had a coworker who was an alternate and ended up sitting in the hall because he just used it.
Okay, I have no problem with that. And if, you're here on call and you feel it's more convenient to be on call here in the courthouse, I don't think it's necessary to be like right out the door, but that's fine. Give us your cell phone number and that's fine. I'm fine with that if your employer is fine with that. That's good. Okay?
Would we still get a pink slip if that's the case? If we stayed?
That's a really good question.
Common practice from other courts I've been in is if the juror shows up there, give it a pink slip. I'm not sure what this court's practice is.
I don't think I've ever had that before, but sure. If you're here and you're on call, I have no problem with that. Yeah,
All right, we'll try it out then.
okay.
I'll come as well.
Okay, then just make sure we have a good cell phone number for you.
Yeah.
So if you're somewhere in the courthouse area and we need you, we can call you and you know to get here.
Okay, thank you very much.
Okay? And then counsel, make sure we have a good number where we can reach you, so if there are any questions from the jury or any requests for readback, we can get in touch with you and
There are three issues, Your Honor. One, when we had the discussion with juror number 5, it appears Mr. Moline noticed before he was excused, all the jury thanked, all the victim's family thanked the juror before he was excused, and he's still sitting, to make sure there's a reminder to not have any contact with jurors. I didn't see anything all during the whole trial. I think that was just inadvertent, but
I think it was a misperception that he had been excused, because I thought that's what the court had said too.
yeah, I was advised of that, and I agree. I think it was, the perception was he was either excused or about to be excused, and he was certainly acting like he was about to be excused. So I'm sure, I know that the family members on both sides know that not to have any contact with the jurors, so I don't perceive that as a continuing problem.
And just so the record's clear, there's nothing the court can do now. The jury was admonished that I violated an order of argument, and on the 23rd, last week, the defense made objections as to what could be argued, and one that the judge ruled cannot be argued is that there was a gambling debt. And Ms. Rodriguez violated that order and was not admonished, and the jury was not admonished. Because I brought those all up last Thursday, and that's the one that the judge said, from the defense request, you cannot argue that. That's not supported by the evidence. The second was, the people asked that we cannot argue about submitting DNA to CODIS. And then she argued that we stopped from being submitted to CODIS. So there's 2 orders that they violated during their closing. The defense was admonished and chastised, told the jury that what I did was improper, and the people did it twice. And neither of those were even sustained nor admonished. And we asked to be heard, and we were denied. So I think the defense was treated, I'm sorry? I think the defense was highlighted that during improper action, it wasn't done unilaterally. Also, during her closing argument, she mentioned a burglary conviction, which was improper. We did object to that. The judge did sustain that. There was only mention of probation. And she went beyond that and started laying down more character evidence of somebody who didn't testify. And we think that was improper. And I think there should have been more admonishment. Nothing we can do now. They have the verdict. They have the case for their deliberations. But that's just something we want to make the record.
Well,
First of all,
I agree that the reference to a felony conviction was improper, and I did sustain the objection, and went beyond just sustaining the objection, telling the jury that there was no evidence that Mr. McStay was aware that Mr. Merritt had a burglary conviction, which was part of the evidence. There was no reference to it being either a felony or a misdemeanor. But I think the discussion, the evidence suggested it was probably a felony, although it was probation. But I agree that that was improper, and I did sustain the objection.
just to clarify, it was the court that used the word burglary, not Ms. Rodriguez. She used felony conviction for some reason.
Which was,
No, I did not.
Commercial burglary.
I did not. I absolutely did not.
Nonetheless, the record will speak for itself. That's my recollection of it. As to the CODIS issue, Mr. Moline brought it up first in his closing argument. So it truly was rebuttal. He stood there and said, and what about this CODIS thing? And left a nice big pregnant pause there to be rebutted. So that was opened the door by them, not by us. As to the gambling debt, Ms. Rodriguez referred specifically to the testimony of Susan Blake and her understanding. Not that there in fact was, but as to hers. That is how that was characterized. She recited to the testimony.
all right, first of all, with regard to the comment regarding CODIS, I think there was testimony on that issue, and I think there was argument on both sides on that issue. So the reference to CODIS, I think, was a fair rebuttal. The discussion about gambling debt, there was certainly evidence that Ms. Blake testified to that there was that Mr. Merritt had a gambling problem, low on funds because of gambling, things of that nature, and that Mr. McStay gave him additional money, helped him out, gave him money, loaned him money, things of that nature. So the reference to a gambling issue in that regard, with regard to Mr. McStay knowing that Mr. Merritt had an issue with gambling, that he had given him additional funds or loaned him additional funds because of that issue, is an appropriate comment on the evidence about would he then give him blank checks. What I recall the ruling was that there was not evidence, and therefore it would be improper to argue that there was an existing debt gambling debt that was owed to either Mr. McStay or anybody else. And in context, I did not see Ms. Rodriguez's argument as saying there was, as of February 1st or February 4th, an existing gambling debt that was owed by Mr. Merritt to Mr. McStay. I think in context, the argument was Mr. McStay would not give blank checks to Mr. Merritt to write on Mr. McStay's account, let alone signing his name to the checks. When Mr. Merritt knew that, or believed that Mr. McStay, that Mr. McStay knew or believed that Mr. Merritt had an issue with gambling and had either given him additional funds or loaned him additional funds in the past. So I think in context, it was appropriate argument and not arguing that there was an existing debt at that time relating to gambling.
Our objection was any mention of gambling debt. There's no evidence of that there was ever anything paid. The only evidence you have is Ms. Rodriguez sitting there. But you heard about a gambling debt, correct? Yes. We objected to foundation. The court overruled that. But the problem was, I was told I violated a rule that I think the court agreed was the wrong ruling. It is proper to argue that they didn't call logical witnesses. We actually addressed this at length last Thursday, and we got the ruling that they can't argue that at all. And they violated, now the court's changing that ruling. Not, they should have asked to readdress that first, like the court puts onus on myself. And says, you violated what was said, that's all I'm going to deal with. That was not done in the same analysis with the people. The court now analyzed, well, since what they said, I mean, that is just, again, a different standard of application of the rulings between defense and people, and it reinforces our violation of due process and effective assistance of counsel objection that I made yesterday. I mean, there's no other remedy to be done.
Well, if I thought that in retrospect there was an improper argument on the facts, I would still admonish the jury. But as I say, in context, I don't think there was. And I don't think there's any basis for any additional admonishment. I understand your argument, you've made your record. Anything else?
I'd ask that the declaration that was filed on Tuesday the 28th be entered in as a court exhibit. I think next in order is Q, and that's it.
Sure.
Thank you.
And there was one issue. The client asked to not be transported unless his presence was necessary. We told him that's not going to be probably possible. But
Well, I assume Mr. Merritt wants to be there if there's a verdict.
he does. He just asked if his presence is necessary that he be transported then and not have to sit downstairs for however long deliberations go on for.
I think that may be an undue burden on the sheriff's department. It's really difficult on them to do transports in the middle of the day. If you get a verdict at 1:30, there's no way really to impose a special transport on them, given the amount of inmates they have to move around.
The DA is not the attorney for the sheriff's department, so, I mean,
Well, I am aware that there is a process for the transportation of people from the jail to court, and it is an undue burden to have the sheriff's office be basically, okay, we needed an inmate transported from the jail here in an hour. I don't think that's reasonable. So and of course, there's no way of knowing how long a jury may be out, especially in this case. I mean, they can come back in a day or two with a verdict one way or the other, or they can be out weeks. So, and whichever one we pick, we're likely to be wrong. So if we say, well, Mr. Merritt doesn't need to be here the first week, they're never going to reach a verdict in a week. Sure enough, first or second day, they'll have a verdict, and we'll have to wait until the next day. So I appreciate Mr. Merritt not wanting to have to get up as early in the morning as they have to get him up to transport him here. But we never know when a jury may reach a verdict, when a jury may say, we're hopelessly deadlocked, we can't continue. There's an issue with having to replace a juror. There's a number of things that could come up. So while I appreciate that, I don't see any way around that.
Thank you.
Okay?
So we're excused till further notice of the judicial assistant.
Yes. The next court exhibit, I'm told, is Exhibit R.
I'm sorry, R, thank you.
So Mr. On's declaration will be marked as Court Exhibit R for the hearing we have with regard to Dr. Rudin.
Did you submit it to us?
Yeah.
Is that it? Then I'll have those concluding instructions I can copy for the jury. Can I mark a copy of this, or do you want the original? Because it's a filed copy.
Your Honor, we should get the DA back.
We should get the DA back, Your Honor.
I'm sorry?
We need to get the DA back.
Just to keep it up.
Brett?
As soon as I get a chance.
Something else?
The defense would object to any filing of a declaration on that issue. If he wants to testify and face cross-examination on any assertions on that hearing that he requested, then it should have to be done in such a order where due process of my client is reserved.
That is up to the discretion of the court of how it feels it should receive that evidence.
It's not evidence in the case. If he wants a hearing, it should be subject to cross-examination, as opposed to sneaking a declaration in at the 11.9 hour of the trial.
It wasn't snuck
We're
in. The
objecting.
counsel was provided a copy, and they were given notice that it would be filed in a day or two at that hearing.
We're objecting. We're objecting.
Well, the declaration is ordered filed, be marked as Exhibit R. The remaining question is whether or not to have Mr. On subjected to cross-examination on that. If there had not been any disclosure of the information from Dr. Rudin, then I would probably allow the cross-examination of Mr. Rhimes. But in this case, we have the fact that when Dr. Rudin first had a conversation or text or some communication with Mr. Rhimes to indicate he did additional work and he was no longer sure of or no longer held his opinion that he could not exclude the vehicle, that his new work suggested the vehicle measurements were off, the length of the defendant's truck or length of measurements were either too short or too long to be the vehicle in the Mitchley video, that Mr. Imes did advise defense counsel of that fact. Subsequently, the defense counsel had communications with Dr. Rudin and obtained all of the additional information. So,
That's incorrect, Your Honor. He refused to tell us the information that he told Mr. Imes when we first learned it on the stand with the court.
well, ultimately, defense counsel did learn the information.
And the email that Mr. Imes sent to us would also contain, I know the court always forgets this line of that email, which was a blatant lie, where he indicated that all the match points still match up. So that was a lie, and it was designed to throw us off. So, but the court doesn't want to include that into that email. So I don't agree that he can just submit a declaration. Even if the court's analysis is the analysis that you want to give it, that's fine. But he requested a hearing on that issue. So we want that hearing, and he's submitting a declaration in lieu of a hearing, and he should be subject to cross-examination on that issue.
There's an intentional misrepresentation of the evidence to this court by Mr. Moline again. Dr. Rudin confirmed under examination that yes, that was an accurate statement that the points match, and he did so in front of the jury as well. So to now put that out there as a false statement is a false statement in and of itself and is misconduct.
So
the court did have a hearing.
The court did not have a hearing where Mr. Imes was subject to cross-examination.
So the question is whether or not what is to be gained by any cross-examination. So the issue, there's two potential issues. One, was there suppression of exculpatory information? The California Supreme Court in the Morrison case, which I previously referenced at 34 Cal 4th 698, indicates under the circumstances where there was the initial disclosure and the defense had the opportunity to obtain the information during trial, that there was not suppression of evidence. Specifically, they said, Supreme Court said, when information is available to a defendant, they said at the time of trial, here during trial, and if the defense didn't follow up and on that information, there's no Brady claim. They further indicated evidence is not suppressed if the defendant has access to the evidence. They said prior to trial, here it would be during trial, by the exercise of reasonable diligence. Here, the defense did have access to the evidence. Finally, they said, in any event, evidence that is presented at trial is not considered suppressed, regardless of whether or not it had been previously disclosed during discovery. So any cross-examination of Mr. Imes would not serve to answer the question of whether or not evidence was suppressed. Morrison says evidence was not suppressed. Second issue then is, was it misconduct for Mr. Imes not to provide the information? Again, we have the fact that Mr. Imes did provide information to the defense that Dr. Rudin had changed his opinion, that he believed that, at least with regard to the length of the vehicles, that which related to his opinion that his earlier model had the vehicle below ground level in order to match, that he did, that since the prosecution provided that, whether or not providing the additional information in the text message would constitute misconduct. The evidence is that after that first communication and after the communication to the defense, that the prosecution told Dr. Rudin, we're not going to use you, you don't have to do any more work, basically we're done. So Mr. Rhimes' declaration is, after that point, he does not recall a text message from Dr. Rudin, and if there was one, he deleted it, didn't pay any attention to it. So obviously he could be cross-examined ad nauseum as to whether or not that's true or not true. Did he see it and say, I'm not going to give this to them and delete it? Or did he say, here's something from Rudin, or we're done with him, delete? I don't think any useful purpose would be served by cross-examination. So I'm willing to let the record stand with the evidence that was adduced with regard to all of the evidence that was adduced at the hearing, with regard to the communications between Dr. Rudin and the prosecution and the subsequent what was and was not provided to the defense. As I indicated, the text message, the follow-up text message from Dr. Rudin, if that the court's view of that was that it is exculpatory, that if the DA was in possession of it, they had a duty to provide it, and that wasn't provided. And whether it was inadvertence or this is what I've already told them, or I'm just not going to do this, I don't think is relevant to any further proceedings here.
Then why should his declaration be filed? Why would the court receive a declaration not subject to cross-examination if your analysis says it's not relevant? What would be the reason to accept that declaration?
Just part of the record. So the request to subject Mr. Rhimes to cross-examination on that is denied.